team of psychiatrists. All right, so we're going to start with the introductions of the leadership team of psychiatrists for gun violence prevention. So I just want to say a few words about psychiatrists for gun violence prevention, P4GVP for short. So after the tragic school shooting in Parkland, Florida in 2018, we took about a year to really get this organization going. This organization is not a official 501c3 or 501c4. We're instead a collection of very concerned psychiatrists, other mental health professionals, and other healthcare professionals actually who are concerned. And we maintain a website with, we think, a wealth of information. And we sometimes participate in various actions like supporting letters to legislators or supporting various policy initiatives. And so we started in 2019. And so this February is the 6th anniversary of our group. And we thought we would, to mark the 6th anniversary of our group, we thought we would do this presentation, which I'll get into a little bit in a minute. But first, we want to just introduce ourselves. My name is Marc Manseau, and I'm a psychiatrist in Brooklyn, New York. So I will pass the baton in alphabetical order to Becky.
So don't make me do that. Hi, I'm Becky. I'm an inpatient psychiatrist. I'm a newer member of the group. I really try and help drum up membership. We really want a lot of people to participate here and learn a lot about gun violence prevention. So really nice to meet you all. I'm not going to do it in alphabetical order, so I'm just going to do Charles.
I am Charles Lee. I'm a psychiatrist in the community in LA County. I worked for many years in community mental health. I work for Kaiser now. I do a little private practice, but with Marc, I set up and some others, we set up the gun violence psychiatrist for gun violence prevention. I'm very happy that we've got Becky and now Imaan here, so I'm going to pass it on to Imaan.
Hi, I'm Imaan Alaidroos. I am a psychiatrist based out of Texas, kind of doing private practice right now. Just found this group because of feeling helpless sometimes, lack of information, wanting to have action, and so excited to be a part of the group.
Thank you. So we've, in the various years of research that we've been doing on everything related to gun violence prevention for our various actions and to keep our website updated. One particular policy kept coming up over and over and over again. That's extreme risk protection orders. It's a particularly promising policy as it's evidence-based, and it is probably one of the more nonpartisan examples of gun violence prevention policies. Both blue states and red states have been passing them. And so when I went to the APA last year, I heard a really wonderful presentation by Drs. Kapoor and Norko on reviewing extreme risk protection orders and what they are, why they're useful, what the evidence is for them. And so I thought it would be great to bring them to this group to host this event, to share with us all their knowledge. So we really are grateful that they were able to join us. Thank you so much. I'm going to just introduce them. I'm going to just read the bios that I got sent. So Dr. Reena Kapoor, is director of the Law and Psychiatry Division, where her clinical work and scholarship focus on the intersection of mental illness, violence, at Yale University, where her scholarship focuses on the intersection of mental illness, violence, and the criminal justice system. She has expertise in the psychiatric evaluation and treatment of violent and justice-involved individuals in a variety of treatment settings, such as prisons, jails, forensic hospitals, and the community. In addition, she serves as the program director for the Yale Forensic Psychiatry Fellowship, teaching and supervising fellows in one of the country's largest training programs for forensic psychiatrists. Dr. Kapoor has lectured internationally and holds leadership positions in several professional organizations. She is chair of the American Psychiatric Association Committee on Judicial Action, vice president of the American Academy of Psychiatry and the Law, and a past president of the Connecticut Psychiatric Society, Association of Directors of Forensic Psychiatry Fellowships, and International Association for Forensic Psychotherapy. Prior to joining the law and psychiatry faculty, Dr. Kapoor completed residency in psychiatry at Harvard Medical School, a forensic psychiatry fellowship at Yale, and medical school at Northwestern University's Feinberg School of Medicine. So Dr. Michael Norko is a professor of psychiatry at Yale University School of Medicine in the Law and Psychiatry Division, forensic policy advisor for the Connecticut Department of Mental Health and Addiction Services, editor of the Journal of the American Academy of Psychiatry and the Law, and a distinguished life fellow of the American Psychiatric Association. He is a past president of the American Academy of Psychiatry and the Law and past chair of the Forensic Division of the National Association of State Mental Health Program Directors. He chairs the Psychiatry and Religion Committee of the Group for the Advancement of Psychiatry. Dr. Norko shared the 2013 Guttmacher Award of the APA and Apple for outstanding contribution to the literature on forensic psychiatry with co-editor Alec Buchanan, PhD, MD, for the Psychiatric Report, Principles and Practice in Forensic Writing. He has published and presented nationally and internationally on a variety of topics related to psychiatry and law, including his special interests in ethics and the use of concepts of dangerousness and risk in psychiatric practice, public sector forensic psychiatry, and religion and spirituality in psychiatry. So we welcome Drs. Kapoor and Norko. We thank you so much for joining us. And without further ado, I will pass the baton over to Dr. Kapoor and hoping that the sharing screen works.
All right. So
Is
Dr.
it working?
Norko's gonna, no, or at least I'm not seeing any slides.
Oh, okay. Hold on.
Aha. Well, I see your desktop seemingly, but not the actual. Aha.
And you see the full screen of the slide, right?
Yes.
Very good.
Okay. So great. So thank you very much to Marc for inviting us here this evening. It's always sort of mortifying to hear your bio read out loud, but we got through that part. And what neither of our bios really told you is sort of how it is that we got involved in the business of giving talks about ERPOs, or red flag laws. So Mike and I have been doing research in this area together for about the past 5 years, but Mike's tenure goes back way further than that, probably about 15 years now, looking at the outcomes and the implementation of what were not yet even called extreme risk protection orders, or ERPOs, when Mike started doing this research. So it really is a pleasure to come and give you, a updated version of a presentation we had given at the APA last year. So neither of us have any financial disclosures to make, but our employers that include both the Yale University and the Connecticut Department of Mental Health and Addiction Services want us to tell you that the views that we express today are our own and not of either of those agencies. The other thing that I'll just say before we start is that, even in a group where it seems like all the practitioners have chosen to be here because of your interest in gun violence prevention, I don't take for granted that everybody holds the same views about guns. But I do know that everybody tends to feel very strongly about this issue, and just ask that we all be respectful of each other as we go through the talk today and in the discussion as well. Sorry, Mike, go ahead. So this is the outline of what we're going to do. We think it will take about an hour or a little more, depending on whether we do questions as we go along. But Mike is going to start out talking about the background of the legislation or restrictions to access for firearms related to mental illness more broadly. So kind of laying the foundation for what all of these laws looked like before ERPOs came onto the scene. And then he's going to talk some about the basic elements of ERPOs, what they entail, how they work. And then we'll switch over to me. I will talk about some of our more recent research about Connecticut. Actually, Mike is going to talk about Connecticut kind of up until about 2013. And then I'll talk about our more recent research, shift gears into talking about what resources and guidelines exist through the APA to help physicians and psychiatrists who are working in this space about some clinical scenarios, what questions are answered and then what ones aren't. And then we should have plenty of time to have questions and a dialogue at the end.
Okay, so the background. So it really starts in 1968 with the Federal Gun Control Act. That act created prohibitions for possession or purchase of firearms. And the language was that it was prohibited to any person who was adjudicated as a mental defective or who had been committed to any mental institution. And it was also prohibited for any person who was an unlawful user of or addicted to any controlled substance. So the first bullet there basically corresponds to things like civil commitment, the appointment of a conservator, being found not guilty by reason of insanity, or being found incompetent to stand trial. And there's some variation from state to state. We'll talk a little bit about an interesting example of that in California in a little bit. But those are the main categories of persons who are considered to have been adjudicated as the federal law says a mental defective. And that language still exists in our statute today. There have been efforts to change it. There were a couple of bills a number of years ago based on some work that we did with the APA, but as of yet, Congress has not chosen to change that language. And the second bullet you'll recognize is what got Hunter Biden into trouble. He was convicted of lying on an application about whether or not he was addicted or an unlawful user. The first amendment of the 1968 Act took place in 1993, and this was the Brady Handgun Violence Prevention Act. Remember, Brady was Reagan's press secretary. He was wounded and disabled at the assault on the president. What the Brady Act did was sort of a two-phase kind of thing. It was actually first introduced in 1987, but it took 6 years for it to get passed by Congress because of heavy lobbying by the NRA against it. What it did first was to impose a 5-day waiting period as an interim measure. What it was intending to do as its permanent solution was to set up the National Instant Criminal Background Check System, and that was put off until 1998 in order to allow for the development of the logistics for how that would work. But the waiting period was something that was the NRA was deeply opposed to, but it passed as an interim measure. If you're interested, there's an interesting Simpson episode about the waiting period. Homer Simpson goes into a firearm dealer and starts asking about a firearm, and the salesman is telling him about the firearm he's trying to sell him and all of its attachments. And then he says, "Oh, good, I'll take it." And the dealer says, "Nope, sorry, there's a 5-day waiting period." And Homer responds, "5 days? But I'm mad now." So if any of you want to see it, it's kind of entertaining. You just Google Homer Simpson and "I'm mad now," and you will find the clip on YouTube. So in 1998, the NICS went into effect, and then that was amended it was signed into law in 2008 in the NICS Improvement Amendments Act of 2007. And what that did was to require state participation in order to receive federal criminal justice funds. So in 1998, when the NICS was set up, the federal government could require the federally licensed firearm dealers to have to use the system before selling a gun to someone, but they couldn't require the states to actually submit records to the NICS system. So in the Act of 2007, states were enticed to do that by the receiving federal criminal justice funds. So you can see here in 2007, there were only a few states that were reporting to the NICS. Connecticut was among them. We'll talk some more about that history in a little bit. But after the NICS Improvement Amendment Act, a lot of states developed reporting laws, and you can see the difference here in the graph. This is data that it's somewhat hard to find on the FBI's website. It used to be easier, and I don't mean since the new administration. It's really been hard for the last 2 or 3 years to find this. Prior to that, it was sort of more in one place. But just to give you an idea of how many records there are of mental health in the NICS, there's over, in July of 2023, which was the last time I went searching for this, there were over 7 million of them. The only category that was larger is this category of illegal aliens with 13 million. But you can see how very few denials in comparison there are based on adjudicated mental health status. And that's different than other categories like conviction, where you can see how many denials there are based on the number of active records. Things like domestic violence, the misdemeanor crimes of domestic violence, and protective or restraining orders. How many denials there are based on those categories, and this other category, interesting, of people under indictment. So you can imagine someone's indicted on a crime, and they're still illegally trying to seek firearms. So there's a lot of denials that correspond to that prohibition. So let's talk about state mental health firearm laws now, which is the other side of the picture. So there are several jurisdictions that do not require reporting any mental health records to the NICS: Arkansas, Ohio, Michigan, Minnesota, New Hampshire, Utah, Wyoming, and DC. Then there are other states that authorize the reporting of mental health records, but don't require them: Colorado, Florida, Missouri, Nebraska, and West Virginia. There are states that keep their own in-state database and require collection of mental health records for that purpose, but don't allow the reporting to the federal system. So Arkansas, Michigan, and Ohio. And then there are some jurisdictions where firearm possession can be prohibited on the basis of a mental health diagnosis or voluntary hospitalization. And Connecticut is in that group, along with the District of Columbia, Hawaii, Illinois, and Maryland. In the Connecticut statute occurred based on voluntary hospitalization in 2013 after the Sandy Hook shootings in December of 2012, and the state made voluntary psychiatric hospitalization a 6-month state prohibition. So it required the creation of a new reporting system and database, because there were no records, there were no statewide records in any kind of centralized database of who had been voluntarily hospitalized. And so that had to be recreated. In 2023, our state also added physician emergency certificates, which is a temporary hospitalization based on one physician's signature that allows someone to be held for up to 15 days in a psychiatric hospital for evaluation and treatment. And they added that also as a 6-month state prohibition, and we had to revise the reporting system again in order to deal with that. I'll say a little bit more about the Public Act in 2013 in a little bit. So here are some examples of other state reporting laws. Florida, since 2013, has prohibited the subjects of 72-hour holds in that state. That's based on the Baker Act. It also prohibits people who were temporarily committed for a substance evaluation or treatment, and a voluntary admission if it was accomplished in lieu of an involuntary commitment. So, if the physician was going to involuntarily commit the person and said that to the patient, and the patient said, "Well, if you're going to do that, I'll sign in anyway." How exactly they determine that it was in lieu of that, I'm not sure, but that's the way the law is drafted. In same year, 2013, New York passed the SAFE Act, where mental health professionals are required to report to a county mental health official any patient who is, quote, likely to engage in conduct that would result in serious harm to self or others. And it results in a 5-year ban. When that act was passed, the mental health community in New York was not consulted. They had no opportunity to comment on the proposed law, and it was really passed without any input from them. And it's still not exactly clear to the extent to which it actually functions. Illinois, the same year, so you can see 2013 was a busy year around the country for state reporting laws. Illinois passed a law that said that various professionals, including medical professionals, have to report outpatients who make a Tarasoff-like threat, anyone who presents a clear and present danger, or anyone who engages in violent behavior or threats. And those reports are made to the state police. California has a 5-year prohibition on anyone about whom a Tarasoff warning was made, or for whom a 72-hour hold was in place for danger. And if you have a second 72-hour hold within 1 year, that results in a lifetime state ban. And in California, they have a 14-day hold, which is an involuntary extension of the 72-hour hold, which is based on danger to self or others, or grave disabilities, suicidality. It requires a probable cause hearing within 4 days of the extension, and a decision has to be made by a hearing officer. And there are a variety of people who can function as the hearing officer, but case law in California has determined that because there is a hearing and a hearing officer and who makes a decision, that qualifies as an adjudication for the purposes of the federal statute. And so California considers that something that results in a NICS report. There are also a bunch of states, 18 of them, that require reporting of involuntary outpatient treatment. So now, obviously, we can't go through all 50 states, but there are resources that allow you to do that. The National Conference of State Legislatures has a listing of all federal and state laws. And the Giffords Law Center has a description of state firearm laws in all states that are searchable by topic. So this is what the National Commission of State Legislators website looks like. The state laws are listed alphabetically. You can browse through them to find your state. And the Giffords Law Center allows for searches by a variety of keywords, and you can look through every state in doing that. So there is some data about what mental health reporting laws accomplish. This light blue line down here are the states that have not had a reporting law, reporting to NICS. So it's been flat since 2008, when the NICS Improvement Amendment Act went into place. So states didn't have to agree to report, but they would give up a certain percentage of federal funds for criminal justice purposes if they didn't. But the dark blue line are the ones that passed those laws, and you can see that there was a sort of a gentle slope up until about 2012, then a big jump to 2013. Again, another marker that 2013 seems to have been an interesting pivot point in the country. And then after that, a continued rise in the number of records that are submitted by the states that have reporting laws. So I'm going to go over for the next few slides how ERPO laws function. So the first thing to note is that ERPO is not the only name. It was a name that sort of got settled on. Red flag laws are sort of how the media likes to refer to them often, but California referred to its law when it was passed in 2014 as a gun violence restraining order. Other places have referred to them as risk-based gun removal, emergency substantial risk order, firearm restraining order, lethal violence protection order, and the term that's used in Connecticut, risk warrant firearm removal. So these are the 21 states that have some variety of ERPO law. And you can see, as Marc mentioned at the beginning, you can see that these are in red states and blue states. It does not seem to belong to one political ideology or another. And interestingly, Oklahoma rather, is the only state that has passed an anti-red flag law. In 2020, Oklahoma passed the first and only prohibition on red flag laws. The law was called the Anti-Red Flag Law Act. And the act, quote, prohibits the state or any city, county, or political subdivision from enacting red flag laws. The other thing to note about this slide is that all of the states here in green that have passed red flag laws, except for Indiana and Connecticut, all of these have been in effect since 2016. So it's a relatively new phenomenon, and we'll talk about the first two states in a little bit. Okay, so how do they work? So what happens is that an individual reports a concern about firearm access to either the police or a court. And there's, in different states, there's different rules about who can report. We'll talk a little bit about that, but some concern is raised about an individual, and then the police do an investigation and apply for what's sometimes referred to as an ex parte ERPO, ex parte meaning without all of the parties, because this happens without the gun owner being there in court. So the gun owners in these things are referred to as respondents. It's also known as a temporary ERPO because it only lasts for a short period of time, perhaps a week or 2 weeks, until a formal hearing is held. But in the interim, the police are allowed to temporarily remove the firearms from the individual, and the individual is prohibited from purchasing further firearms. Often there's also a prohibition on purchasing ammunition, but the individual can also be referred for mental health evaluation, and depending on the situation might also be arrested, right? So you can imagine that some of these scenarios where the police show up and tell someone that they're there to remove their firearms, that sometimes those don't go smoothly, and the person objects, and maybe in the course of doing that, they assault the police officer or do something else, or in the course of it, the police notice some other illegal activity like drug paraphernalia or whatever. So persons can be arrested as well. And then there's the hearing. It's within some period of days, and at the hearing, the judge has to decide whether or not the firearm access will be restricted, or whether the request for that restriction will be denied. So if the criteria are met, then the final ERPO is issued for an additional period. That's often a 1-year period. It can be longer, and we'll mention that as well in a bit. Courts can also order evaluations, mental health or substance evaluations. And if the criteria are not met, then the firearms are returned to the respondent. So they would have been removed for maybe a week or two, but then are given back to the respondent. So Connecticut was the first state to adopt one of these laws, and that happened in 1999. But there was a step before that, which started in March of 1998 with the Connecticut lottery shootings. One of the employees of the Connecticut lottery, who it was later learned had a history of depression, a history of psychiatric hospitalizations, was disgruntled, was upset about being passed over for a promotion, and came to work one day with firearms and started shooting his coworkers. He wound up shooting several of them. The director of the Connecticut lottery managed to get him to chase him out into the parking lot. And while he was running, he shouted back to his coworkers that they should go run and hide. And then out in the parking lot, the man shot the director before taking his own life in the parking lot. So 4 people were killed in addition to the man who did the shootings. And that happened on March 6th. 5 days later, an act was introduced in our legislature. The legislature was in session at the time. An act concerning handgun safety was referred to our Judiciary Committee. 5 days after that, there was a public hearing about it. And less than 2 months later, Public Act 98-129 passed. So this was, a very rapid response to something that was very challenging, very sad. And, when things like this happen, legislators feel a tremendous push to try to do something about it. So what they did was require the reporting of civil commitments. People who were civilly committed were not allowed to possess firearms in Connecticut, but the only way that that was enforced was when you applied for a permit, there was a question on the application that said, have you ever been civilly committed? And if you answered no, untruthfully, there was no way for them to know otherwise, and so you could get a gun. So what they basically did was end the honor system for civil commitments. So it required that the Department of Mental Health and Addiction Services collect this data and share it with the state police, and it required that the state police share firearm permit data with the Department of Mental Health and Addiction Services, but that neither of them reveal the full database of each of those, but only when match. So we had to create a black box system in order to make that happen, so that the data would go in, and every night the system would look for matches, and if there was a match, both the state police and the Department of Mental Health would be notified and would take the appropriate actions at that point. And that's the way the bill was left. The following January, a new bill was started that made some minor amendments to that public act, and then the legislature came into session again, and then the Columbine shootings occurred. And after that happened, people were interested in doing more than making minor amendments. And it started out as a discussion of having psychiatrists evaluate everybody who wanted to have a gun. And the mental health community, and particularly the public sector health community that was going to assume that responsibility most likely, objected to that. We argued to the legislature that there was really no basis for us to do that, and it was also stigmatizing. And so during the course of the session, this evolved to a less stigmatizing notion of imminent risk, regardless of whether or not the person had a mental health history. And that's the way that the statute went forward. So this is how our statute was defined. In order to get the risk warrant to remove, there had to be probable cause to believe that the person posed a risk of imminent personal injury to self or others, and that was based on recent threats or acts of violence, recent acts of cruelty to animals, and then the judge could also consider any reckless use or display or brandishing of a firearm, the history of attempted or use of physical force against other people, prior involuntary psychiatric hospitalization, so that wasn't eliminated entirely from the statute, and then illegal use of controlled substances. It limited the seizure by the state to 1 year, and there were not any provisions in the statute for extending it after 1 year, and we'll talk about that in a little bit. So this was the first law of its kind in the nation that allowed the seizure of a gun before the owner had committed some act of violence. 6 years later, Indiana passed a similar law after another tragic event where 4 police officers, actually 5 police officers, were ambushed. One of them was killed and 4 others were wounded. And so a very similar law was passed in California. It allowed the police to remove the firearms without a warrant or with a warrant. And we'll talk a little bit about that distinction when we talk about some of our key informant interviews. And then California passed the first gun violence restraining order in September 2014, again, following another tragedy, the Isla Vista shootings in May of 2014. And the law became effective in 2016. And it was patterned after domestic violence restraining orders. And it also allowed family and domestic partners to request the restraining order. So I mentioned 2012 before as a pivot year around the country, and you'll remember that the Aurora theater shootings took place in July of 2012, where 12 people were killed and 58 injured by gunfire, and then the Sandy Hook shootings in the elementary school in Connecticut in December, in which 20 children were killed and 6 adult staff were killed. The legislature was keen to act as a result of that, and Public Act 13-3 was signed into law the following April. This is where we added voluntary psychiatric admission as a prohibition. There was some discussion and debate about that. Sorry that my video keeps clicking. There was some debate about that. A number of psychiatrists, for example, thought that, if anything, perhaps the physician's emergency certificate should be the trigger. Not all psychiatrists thought that. Legislators thought that that was perhaps problematic because this is a constitutional right based on the Second Amendment, and to have that abrogated by one physician signing a paper seemed like too far a step for them, so they didn't want to do that. And again, this was a discussion. There were public discussions about this, but not about the voluntary psychiatric admission. That actually happened in backroom discussions, and the discussion was that they figured that if a person voluntarily admitted themselves to the psychiatric hospital, they were admitting themselves that they had a mental health problem and that it required inpatient care, and so it was a serious need, and so it would be less likely that this would be found to be unconstitutional because the person had already admitted themselves. So, this is a step beyond the adjudication that was the prohibition in the federal law. And the other thing that the legislators relied on was the fact that it was only a 6-month prohibition. And so they thought that that was a reasonable temporary measure in these situations. Now, this also required, like as I mentioned before, the reporting of a new system and a database, and so we had to create a database and a system for every one of the hospitals in the state that admitted people to inpatient psychiatric treatment, so that they would report those. And all of them chose to do that, except for the VA, which decided that since it was a federal institution, it was not subject to state law, and the VA has never reported voluntary admissions to its system. So here's a chart of what happened with the law. So remember, the law was passed in 1999, and you can see how for the first 9 years, there are very few risk warrants that were passed in the state. And then it ticks up a little bit in 2007, but still not dramatically. And remember that Virginia Tech occurred, the shootings there in April of 2007. And then after that, there was a little bit of a rise. Here we've listed the Aurora and Sandy Hook shootings. 2013 was a largest number to date, dropped down a little bit, but relatively flat. And then there was the Orlando nightclub shootings, the Las Vegas shootings, the Parkland shootings that Marc mentioned at the beginning. And that was the year in which there was the largest number to date. And then it backed off a little bit in Connecticut. We studied the first several years through 2013 and reported on this in an article in 2014. And this is sort of interesting what the triggers were, because it seemed to be age dependent of the respondents. So when people are younger, the issues are mostly relationship problems, this light blue or turquoise bars. In later life, loss was the biggest driver by health problems. And you can also see that depression has peaks at 3 different stages. So young people, middle-aged people, and then, as we know, the risk of suicide and depression in elderly, particularly men. So it's an interesting graph of what was driving the triggers for the crisis that was the subject of the whoever reported it, the concern that they had. It's also interesting to note that the FBI and the Department of Justice report that financial issues are the most common motive behind completed suicides. As part of this study, we did interviews with key informants. We talked to police officers, a judge that had been handling a number of these cases, a prosecutor who was handling them, a defense attorney who was representing the respondents. And what we found were concerns that the low number of warrants in the first decade were related to the fact that there were limited police resources. We would hear from some police chiefs who would say, on a night shift in my town, I have 3 officers. If I have to send 2 people out to go do one of these investigations because the law requires 2 affiants to fill out the form, then there's only 1 person left in the entire town to do our work. They also thought it was sort of cumbersome. They thought the training was not done well, little public education, and so police officers felt like they didn't really know what they were doing. Another concern we had was that police officers, police departments, were hampered by the fact that they didn't necessarily have storage facilities for the firearms, and so they were worried about what they would do when they collected them. We also heard concerns that from some police chiefs that there were people in their community that they knew that they didn't want to give the guns back to after 1 year. So in Connecticut, there's a two-layer application process for a gun permit, and the first is a local one, and in a town that would often fall to the police chief. And the police, are know who in their community has been problematic, and so there were people that they've had lots of encounters with, and they didn't want to give their guns back. And so we heard some stories about how sometimes at the 1 year mark, the firearms would turn up missing. And nobody could find them to give them back to the person. So that was one way that the police found to deal with what they thought was a difficult situation. We collaborated with some other colleagues. Jeff Swanson was the lead author on this article to look at the effect on suicide outcomes of the seizures. And what we found was that the population of people from whom firearms were seized had a suicide risk that was 40 times that of the general population in the state. And then we used a counterfactual analysis. In other words, how many extra deaths would have occurred if the gun seizure hadn't occurred and the subjects had a firearm available to them rather than a less lethal means. So, firearms are over 90% effective in suicides, and other means are far less effective. And so we did a counterfactual analysis and extrapolated that for every 10 to 20 firearm seizure events, depending on what assumptions you make, one suicide was averted. And we also discovered that the law took years to work itself into routine practice as a useful tool both for public safety and suicide prevention. And this is where I'm going to stop. I'm going to stop sharing, and Reena will take over and share her screen.
Right. I don't know if while we're doing that, if people had a question or two, we could certainly take one. Okay. Whoops. 1 second. I've just gotta find my little button. Okay. All right. You guys are seeing this?
Yes.
Perfect. Okay, so we're shifting gears and we're going to be talking about the research on this question of ERPOs are often explained in the media or by political figures as this is the common sense answer we can all agree on that's going to help us prevent mass shootings. Oftentimes, as Mike was saying, these laws get passed in the aftermath of a particularly horrific mass shooting. And it's something that people can agree on. But we were, just as researchers, really curious to know, how is this playing out? Are the people whose guns are being taken away, how do they compare with the people who maybe have perpetrated mass shootings, or even just at a very basic level, how does this work? And so that's what the research that we've been doing is. So I'm just going to start here with how often are these laws being used? So this graph, and there's a series of them in the next couple of slides, this one just shows you absolute numbers of how many ERPOs are there per year in the states that publish data, either in official state databases or have had peer-reviewed studies. So one thing we found when we were just trying to look at media reviews and include all sources of data is that they don't all use the same definitions. And so this was kind of pared down to just the places that have official sources of data. And you can see that New York and Florida really lead the pack in terms of the absolute numbers of ERPOs every year. But you might also think, well, maybe that's not telling us much, because those states, Rhode Island has a very different population than New York. And so, of course, they're going to have less ERPOs. They just have less people. So looking at this a different way, is per capita. So how many residents are there in that state? And so that gray line is kind of the national average. And you can see then that the states look a little bit different when you take into per capita. The ones that pop out as way above average are Indiana, Maryland, and again, Florida and New York, but also Connecticut and Rhode Island. But then you might say, well, actually, people isn't the right denominator because gun ownership isn't equally distributed across states. And so the only people for whom an ERPO is relevant are the people who possess guns. And so maybe the correct denominator when we're trying to look at how often is this used is actually gun owners. So this is just the same data showing you how many annual ERPOs there are per 100,000 gun owners. And here, like, again, it looks similar to the population graph I showed you just a minute ago, in that New York now has a lot of ERPOs and fewer gun owners, and so it's leading the pack. But then Maryland, Florida, Connecticut, Rhode Island, and Indiana are all above average. So for a while, we had in the peer-reviewed literature, peer-reviewed studies of state-level ERPO laws. So Mike and Dr. Baranowski's findings looked at Connecticut from 1999 to 2013. There's also George Parker had published some data from Indiana, from their law. And those were the only two that existed before 2016. And then since 2016, there have been some researchers who have published data from Washington State, from Oregon, from California, from Florida, most recently. And what we did was we basically partnered with the people who were doing state-level research on ERPOs to create a coalition and a multi-state study of ERPOs, which was the first of its kind. So it was this six-state partnership funded by the National Collaborative on Gun Violence Research, or the NCGVR. And those are the 6 states that participated: Connecticut, Oregon, California, Florida, Maryland, and Washington. And it involved an analysis of over 6,700 ERPOs, which is by far kind of the largest sample studied at the time that this was happening. And we're really trying to focus on implementation and jurisdictional variation. So are the laws written the same, whether it's Connecticut or Oregon? Are they implemented the same, whether it's Connecticut or Oregon or Maryland or Washington? We also then were able to take that same data set and look at a lot of different specific questions, and I'll show you just a handful of those. One is about mass shootings, another about geriatric or cognitive impairment, another about suicide prevention. But there have been a number of kind of follow-up papers as well from this study. But so for these next few slides, what I want you to keep in mind is we're just talking about Connecticut. So this is, Mike had showed you a slightly different version of this graph, maybe 20 slides ago, and it stopped in 2020. And so ERPO usage between the 1999 passage of Connecticut's law and 2020, what ramped up over time. Certainly there was relatively big jumps in 2013. That was after the Sandy Hook shootings that were here in Connecticut. And then again in 2018 after Parkland had happened. But what I want you to look at is the very far right of this graph, which is that our state context has really changed in the last couple of years for reasons that I'll tell you about in a second. In June of 2022, a new law took effect in Connecticut that was meant to kind of modernize Connecticut's ERPO law. The legislators weren't discussing this with the Department of Mental Health and Addiction Services, but somehow they had gotten the idea that our law was outdated or it wasn't modern. And so they made some tweaks to it that ended up having the effect of exponentially increasing the number of these warrants. So the reason I'm telling you that is in part because the study results that I'm about to show you are from before that law change. Actually, yeah, I made a typo on this. It's supposed to say June 30th, 2020 is the end of our study date, not 2024. So what happened in June of 2022 in Connecticut is that they basically created two different processes, kind of like one where whether this person has guns or not, a person, usually a police officer, can apply for this warrant, this risk protection order to prevent them from possessing or purchasing a weapon in the future. And then if they already had a gun, then there would be on top of that this risk warrant that allows the police to go search the specified location and seize the guns. And so you no longer needed to have a gun in order to get an ERPO, which was a component of our older law. You no longer needed probable cause that the person possessed a firearm. And it also expanded the weapons beyond just firearms to other deadly weapons. It expanded the class of petitioners to include not just law enforcement officers who were always able to do this, but now family members, household members, and medical professionals, which we'll come back to at the very end. And one thing that we are concerned about, or at least has come up as a civil rights issue, is that the 2022 law also made it so that an RPO continues indefinitely. So it used to be that it was for a year, or it could be even less if that's what the judge said. And then the burden would be on the prosecutor to petition to, renew it. And now this just lasts indefinitely unless the respondent or the person whose guns were taken away is the one who goes and petitions the court for termination of that order. And so it really is a very different process. And that is, all of these changes have in part accounted for the huge number of increased petitions that we've seen in Connecticut in the last couple of years. So looking at the earlier data up until 2020, now we're getting into the questions of who's calling the police, or like how is this working at the ground level? So here you can see that it is, between a spouse or a partner, a romantic partner, or another family member, that accounts for almost half of the people who are initiating ERPOs. And then there's this smattering of friends, coworkers, healthcare professionals. There's interestingly about 8% of people who called themselves the police to try and have their guns taken away. And then this other category of 30% that just is listed here as other, that is neighbors, passersby, strangers, like those people make up another really sizable percentage of who is calling the police to initiate an ERPO. So then if we look at whose guns are removed, so in our study, we had about 1,400, well, exactly 1,407 petitions. And that translates to 1,394 unique individuals, meaning that 13 people in our sample had more than one ERPO in that 7-year period that we were looking at. But even like if you do the math, it's still very, very rare usage. One in about 12,000 Connecticut adults and one in about 2,800 gun owners in our state every year are the respondent of an ERPO. It is mostly men, overwhelmingly men, about 92, 93% men whose guns are removed. Their mean age is about 47 years old. And they're overwhelmingly white, though I will say with the caveat that the respondents' race, we only had that information for about half of the cases because of the form that the police officers were using to fill it out. The older version of that form didn't ask them to comment on race. And even in the ones where it was reported, it's the police officers report of someone else's race. And so we don't know what methodology they're using to determine that. And then most of the ERPOs in Connecticut are initiated in suburban or rural communities. So Connecticut doesn't have major urban centers. You know, it has a few medium-sized cities like Bridgeport, Hartford, New Haven. And what we're finding is that the ERPOs don't come from those areas. They come from the suburban and the rural communities of the state. And that the majority of the people in our study don't have any history of contact with the state mental health system. So DMAS means Department of Mental Health and Addiction Services. And so that could mean that they are getting treatment privately. It could mean they have no history of contact with the mental health system. It's just that this is the data point that we had access to, is whether they had had previous involvement with DMAS. So that was in a lifetime. Most people don't have any history of DMAS contact. And then at the time of the ERPO, only 7.1% of them were actively in DMAS treatment. So that tells you a little bit about, this is not the kind of SMI state mental health system population who's being picked up by our ERPO system. So I mentioned a little bit about race and ethnicity, but this just shows that to you graphically, that again, 93% of the people whose ethnicities that we knew of in our study were white. And then after that, about 5% Black. And then everybody else is, you know, negligible percentages in our study. So we also looked at how many of the respondents had mental illness and substance use disorder concerns. And the reason that that's of particular interest is not just because we happen to be psychiatrists, but also because one of the advantages of ERPOs over the earlier kinds of restrictions that Mike told you about, like restrictions based on civil commitment or conservatorship, is that it was really, ERPOs were trying to divorce the idea of dangerousness from diagnosis of mental illness. You know, these laws were written saying, if you're a danger to yourself or others, we can take your guns away temporarily. And it doesn't necessarily link that to a history or a current diagnosis of mental illness. But we wanted to see, you know, can we look at these petitions and try and extract some information about how often do people have mental health concerns that are raised in the petitions? And what we found is that about 82% of our ERPO petitions in Connecticut involved a respondent having some kind of mental health concern. But it's a really broad range of what those mental health concerns might be. Like, there were relatively few, only about 16%, where the police officer's report or warrant mentioned a specific mental health diagnosis or a specific prescription of a medication. Much more often, about 75% of the time, it was more like vague statements where the officer, you know, interviewed the respondent's mother, and they said, oh, he's been depressed, or he doesn't seem like himself, or he's been acting strangely. It was those kinds of reports that we were seeing in the ERPO petitions far more often than someone saying, oh, this person has schizophrenia, this person has bipolar disorder, they're off their medication. Much more vague concerns. We also included in this, if the police officer sent the person to the emergency room for psychiatric evaluation, kind of for any reason, then that we coded as a mental health concern, as a vague statement as well. So part of it is just the high numbers have to do with the way we defined mental health concerns. But still, you can see that this is a kind of a disturbed population overall. We also looked at respondents who have alcohol or drug use evident in the petition. And so here again, it's about half of the people had some kind of alcohol or drug use concern, and mostly alcohol, less so drugs, and occasionally both alcohol and drugs. And then when we drilled down into which drugs, it was opioids and marijuana, inhalants, stimulants, and or you just couldn't tell from the petition what drug the people were referring to. And the opioids and marijuana certainly just anecdotally kind of mirrors what you see in the community in Connecticut with regard to drug use. So it wasn't anything too surprising there. So then we looked at why are people's guns being removed. So when the law is structured that you can take guns away if a person is a harm to themselves or a harm to others, then how is that playing out? So most of the people, over 2/3 of them in Connecticut, it is suicide risk or harm to self. That's the concern that leads to the guns being taken away. And then in about 40% of cases, it's harm to others, some overlap of harm to self and others. And then we also had some cases where it was neither, and that has to do with some of Connecticut's particular definitions of there's a little loophole of you can be neither and still the judge can grant the ERPO. So what happens at the time of the gun seizure in addition to just the police coming and taking the guns away? So I mentioned this a moment ago, but a lot of people are taken by the police involuntarily to a hospital for psychiatric evaluation. So that's almost 80% of our respondents. And then another roughly 19% were arrested at the time of the ERPO, again, because maybe they were resisting arrest, maybe there was some domestic violence concern, maybe there were threats. And then there were some permutations of people being both arrested and taken to a hospital, or neither of those things happened. We just broke that down for you. So what percentage of the petitions are granted in Connecticut? So we had about 1,200 petitions that we could look at that question for. And we found that a little over half were granted. And that was, at least to me, a lower number than I was anticipating. But what we found was that a lot of the petitions were either denied or dismissed, but they also had an other outcome. Where the judge perhaps agreed to transfer the firearms to another owner. The person agreed to relinquish them for sale. It was almost as if the court was really working with the respondent to take care of the concern about them having guns without issuing the ERPO and trying to find these other ways to manage the situation. And that happened in over a quarter of the cases in our study. We then tried to look at, statistically, what factors are linked to whether the judge grants the petition or not. And in Connecticut, the only thing that we found were loose associations between when the petition contains a specific mental health diagnosis, then the judge was more likely to grant the ERPO. And if the respondent were threatening violence, not necessarily even using violence, just threatening it, that was correlated with a higher likelihood of the petition being granted. But everything else, every other variable that we looked at was not correlated with the judge's decision. So things like race, things like substance use, things like suicide risk, none of those were correlated with the ultimate outcome of the petition. So that is kind of bringing our Connecticut data to a close. And then I'll spend just a couple of minutes talking about our 6-state papers that we have published. So the first one of these was on mass shootings. Again, just because this is such an important area for public policy, because ERPOs really are often touted as the solution or a solution to the problem of mass shootings. And so here you can see that overall, when we looked at our data across the 6,700 petitions in 6 states, that 9% of them involved a mass shooting threat. So the definition we used for mass shooting threat was a threat to kill 3 or more people. And that's slightly different than other sources about how you define mass shooting threat. But that's how we did it. And that there were really big jurisdictional variations. In Connecticut, we were the lowest, only 3% or so of our petitions had a mass shooting threat. Whereas in Florida, it was all the way up to 12.5%. We don't know exactly why that is. But there's something about the way they're being implemented that in Florida, it's much more likely to capture someone who is making a threat of mass violence. We also had a paper looking at older adults and ERPOs, and again, around 6,700 petitions across the 7 states. About 10% of them involved people who were over 65. And I think the hypothesis here was that, older adults with cognitive impairment might be the ones who were really posing a risk with firearms. And indeed, we found that 14% of the petitions for older adults involved some degree of cognitive impairment and or suicide risk. And unsurprisingly, some of the people who had cognitive impairment were older than those who were not cognitively impaired. And then this one is just from late 2024. Our colleague Jeff Swanson, who Mike had told you about the 2017 study about a counterfactual analysis. Basically, Jeff had led the group who was looking at the updated data from our 6-state study. We only got 4 states worth of data for this because you had to match it with death records from suicide in the state, and that wasn't available in all 6 states. But in the ones that we were able to study, then that same counterfactual analysis of how many extra deaths would have occurred if the respondent had had access to lethal means in a firearm rather than what they had access to, found that 1 life would be saved for every 17 to 23 ERPOs overall. And then for the subset of those ERPO respondents where the concern was suicide risk as opposed to violence, then 1 life is saved for every 13 to 18 ERPOs. So the take-home points from our research and that of our colleagues is still that ERPO laws are gaining traction, certainly, but they're still used very infrequently. And at least in Connecticut, they're more likely to be used because of a respondent's concern about suicide rather than violence potential. That if you're going to have an image in your mind of a prototypical ERPO respondent, the person whose guns are being taken away, it's a middle-aged white man who's living in a suburban or a rural area. About half of the respondents in our study had a history of substance use or mental health diagnoses, and that courts were granting the ERPO petitions in the slight majority of cases in Connecticut, but there are pretty big jurisdictional variations. Like when we looked at that across 6 states, it really varies quite wildly from, 20% in some states to almost 100% in others. And then the last thing I mentioned is that ERPOs do show promise as a strategy, certainly for suicide prevention. And I think the mass violence prevention is less evidence-based, at least at this point. Then switching gears to the last little piece of this talk, which is what does all of this mean for mental health professionals? It sounded like from the introductions that a lot of the physicians in the room or healthcare professionals today might be psychiatrists or working in some kind of mental health field, but it applies more broadly than that as well. So we'll start with just reviewing, what does the American Psychiatric Association say? I see some people in the room who I recognize from the APA, from the Assembly and other places. And so this will be very familiar to you, is that, the APA has had various positions related to firearms and mental illness for a long time, some of them dating back to the 1990s. But after the Sandy Hook shootings, happened in December of 2012, then there was, just like with you guys forming after Parkland, a lot of fervor around, well, we've got to do something. And so there were a much more kind of consolidated, larger scale statement through the APA, passed through the assembly by the time 2014 happened, and became official APA positions. So it's a pretty long statement, but it does have some pieces that are relevant to this particular question of mental illness and firearms access. So here are a couple of statements that the APA is in support of. So reasonable restrictions on gun access are appropriate, but such restrictions should not be based solely on a diagnosis of mental disorder. And non-adjudicated events should not serve as sufficient grounds for disqualification for gun ownership and should not be reported to the NICS system. So this isn't about ERPOs. This is about the kind of firearms restrictions that Mike was talking about earlier in the talk. So that if a physician involuntarily commits you on a 72-hour hold to a psychiatric hospital, the APA is saying, we don't think that's sufficient grounds to report you to NICS and to prevent you from having a firearm, which at that time, is a lifetime prohibition. And that reasonable restrictions are appropriate, but like diagnosis, mental illness shouldn't be the sole consideration. The next part is extending restrictions on access to firearms to individuals who voluntarily seek mental health care and incorporating their names and mental health histories into a national registry is inadvisable because it could dissuade persons from seeking care and further stigmatize persons with mental disorder. So here again, this is not about ERPO. This is about what Mike was talking about when he said Connecticut passed a law saying if you voluntarily admit yourself to a psychiatric hospital, then you have a 6-month prohibition on firearm access. So the APA is saying we're against that. The next piece. So because privacy in mental health treatment is essential to encourage persons in need of treatment to seek care, laws designed to limit firearm possession that mandate reporting to law enforcement officials by psychiatrists and other mental health professionals. Sorry, I feel like there's a typo I put in here, but basically this is about the SAFE Act and those laws in 2013 that were saying, you mental health professionals, you psychiatrists, you are mandated reporters now of danger to self or others. And the APA is saying we are against laws like that. So that's what was there in 2018. I will say the APA has, its system is that every position statement has to be reviewed every 5 years and then either revised or adopted again. And so right now, it's been more than 5 years. Some of this seems to have gotten a little held up by the pandemic, but there is a new position statement that's under review. The Council on Psychiatry and Law had put it together, and it has to go before the assembly as a next step, which may happen in May of this year. But it consolidates multiple older position statements, and really the only thing that is new is that in that 2014, 2018 statement, at that time, we really felt like there wasn't solid evidence to support a position one way or another on ERPOs for the APA. And I think in reviewing that through a more modern lens, now the APA is coming out with a statement in the revised position statement, assuming that it passed, that explicitly supports ERPOs as a strategy to help prevent access to firearms for people who pose a danger to themselves or others. So of course, you guys are wondering, is ERPO a tool for clinicians? Or maybe you're not wondering, maybe you've decided like this is something that clinicians should be using. And I think you're not alone if that's how you feel, is that you will see in a lot of prominent healthcare journals, as well as in the lay media, a lot of pro-ERPO kind of as a suicide prevention tool kind of articles, especially in the last few years. And there are now still the minority of states that have an ERPO law. allow physicians or any kind of healthcare professional to be a petitioner. But now there are, I believe, 5 states or 4 states, New York, Connecticut, Maryland, and somewhere else, and Washington, D.C. Oh, Hawaii, sorry, where a physician can be a petitioner. And that may be the trend, kind of to expand petitioners beyond law enforcement professionals into and include healthcare providers. Some of you may know Paul Nestat, who's at Johns Hopkins, a psychiatrist who has been a leading voice in the community, in the public on this. And here's just a quote from a few years ago where he says, "I've had success with family meetings and interventions during which I've guided patients to safely store their weapons at a local gun shop or a range or with a close friend until the crisis passes. However, for the minority of patients who are at significant risk of hurting themselves or others, but are unwilling to set aside their firearms, a legal tool called ERPO can be life-saving." And I think he reflects a sentiment that a lot of practicing psychiatrists have had, which is like, we've all been worried about a patient at one time or another. And you hope that you can resolve this by talking to them about, storing the guns with somebody else. But there might be some people who just aren't willing to have that discussion. And so is this a tool that can be brought out in those circumstances? So at least in 2019, the majority of physicians had never heard of this. There was a study of the ERPO law in Maryland and physician knowledge. And in that study, they found that over 70% of physicians had never heard of ERPOs or red flag laws. And then, the study design was that they explained what it is. And then they asked the physicians, do you think that this would be helpful? Do you think that you have patients to whom this apply? And over half of them said, yeah, actually, several times per year, I see patients for whom ERPO could be a helpful strategy. The challenge is in implementation. So, as Mike and I have kind of given different versions of this talk in different places, some of the questions that mental health professionals raise are like this, can I request the removal of guns from my patients? Like, what if they're not the patient's guns? This happens a lot where it's, especially if you treat children or adolescents and it's the parents' guns. How's that supposed to work? Like, who am I asking the guns to be taken away from? How much clinical information, if I'm the one who's calling the police, how much should I share about what's going on? What do I do if I'm asked to appear at a court hearing, in the middle of my busy clinical day? Should I continue working with a patient whose guns I've asked to be removed? They might be quite mad at me because of this. What happens to my own safety in that circumstance? And then this one comes up too, is like, also, let's say we're after the person's guns have been taken away and the patient comes to you and says, "Doc, can you write me a letter saying that I'm good now and can I have my guns back?" Do you do that? How do you do that? How do you assess that? And these are some of the kind of real life things that are playing out. So in 2018, I had led a working group at the APA trying to answer some of those questions for clinicians about what are you supposed to do with all these tricky real life clinical issues? The challenge was it was 2018. Or actually, when we started working on this, it was probably early 2017. And so it was a very different context. At that time, there were only 6 states that had an ERPO law to begin with. Very few of them had published data. And so we were really just trying to mine very sparse data to provide guidance to psychiatrists. And so there really weren't great answers to some of the questions. And that's what we had to write in this resource document for a lot of things. Physicians had questions about liability, like what happens? Am I liable for reporting and breaching confidentiality? Am I liable for not reporting? And so we really did the best we could, but oftentimes had to say, most of the important questions remain unanswered. And you have to remember, at least at that time, that ERPO laws were not written with healthcare professionals or physicians in mind as the petitioners. They don't typically provide an explicit exception to confidentiality. They don't provide liability from reporting or from petitioning or from not petitioning, and that the best advice was really just not to worry about this alone, is to really seek guidance from your hospital's legal counsel or from your healthcare system about how it is that they advise you in your local context to handle these situations. But since that time, that was 2018. It's probably ripe for a redo of that resource document. But there are a number of kind of promising newer strategies that have happened since then. So some of the newer ERPO statutes do include liability protections for people who are reporting in good faith about the risks that they perceive with the person's access to firearms. There's also been a more robust effort at education of the public, of healthcare professionals, and of law enforcement officers about how to do this. And then the other strategy that you may have heard about is something called ERPO navigators, which is some of the larger healthcare systems, even though this is still in a pilot phase, have designated individuals who maybe work in your hospital or in your ER, in your outpatient clinics, who you can call as the clinician and say, hey, I'm worried about this person's access to guns. Can you help me either do an assessment of whether we need to file an ERPO, and then can you actually fill out the paperwork, handle it, submit it to the court, be the person who's going to testify, so that it's kind of removing that obligation from the physician who's the treater, and making it both logistically easier and potentially then saving kind of that doctor-patient relationship as well. Here's another strategy which has popped up. This is a Pause to Protect, which is a website you can go to, but it includes a national map of firearm businesses who are willing to consider serving as a storage facility, a safe storage. So rather than needing an ERPO, this is another strategy potentially for someone who can voluntarily just go and say, can you take my guns for a little while? Pause to Protect, it promotes the activity by firearm owners and businesses to help prevent accidents, theft, suicide, other violence. So not just about kind of ERPO or suicide risk, but a little bit broader than that. And that the idea is that this is just another avenue for if you're going through a crisis or someone is, and you're worried about their access to firearms, that you can go voluntarily give them to one of these Pause to Protect agencies. So where do we go from here? I'm sure I look forward to kind of hearing from the group about what you think about all this. My own take on it is that I maintain optimism, but a little bit of cautious optimism about ERPO laws. I think there is now a fairly solid evidence base to show that they are effective as a suicide prevention tool. And I really like the idea that these are based on dangerousness disentangled from mental illness or mental illness diagnoses, which is really different from the way that this area was approached in the era before ERPO laws. I think that the more states that pass laws like this, the more data there is to analyze, and the more we will learn about what works and what doesn't, in educating people about how they should be used, and how to really kind of promote safety with firearms in our communities. And so my hope is that in these next few years that more studies will help compare implementation across states and develop, what we can all consider to be best practices in this area. So there are some references for you, and I will stop sharing so that we can discuss.
This is Leslie in Hawaii. Thank you for this. Your data answered my question about what the general knowledge is about ERPO laws, which is little. So I would say where we should go from here is make sure people know about it. And so my experience, I'm going to be 83. I'm retired for 8 years, but in 20 years in community mental health, I dealt with this a number of times, and it came down a number of different ways. And I think, just having the discussion, whether it's a responsible family member who takes it away or whatever it is, all the different alternatives. I think from years and years and years ago, people didn't know about it. I guess they still don't know about it. So I think that would be the next step, in my opinion. Maybe the foundation could do something because they're so good at education and stuff like that.
Yeah, I mean, I think that, assuming that the new position statement passes, it will then, APA will have an official position in support of ERPOs, and that opens up a lot of avenues about advocacy, about legislative and judicial and education efforts through the foundation. I think up until now, when the APA doesn't have a position on something, then it's really harder to get those initiatives going. And so I think this is a really important moment.
I think kind of going through the questions from the chat, Dr. Capasso is wondering which specific mental health diagnosis was related to the ERPO petitions in Connecticut. You talked about that one law that was passed, and I think there was like even specific mental health diagnoses that could be included.
My question was, I think you mentioned that you said specific mental health diagnoses was associated with a higher chance that those would be granted. I was wondering, thank you, Imaan, whether it was a specific diagnosis, like is it a psychotic illness, a major depressive disorder, or was it that specific, or was it just having a specific diagnosis?
The latter. It was like the category was sort of if any specific diagnosis were mentioned in the petition, or even like a specific medication that the person, like the officer went to the scene and they found a prescription bottle with the person's name saying
I see.
Abilify 5 milligrams, then we coded that as, specific, like bona fide diagnosis because they were in treatment. As opposed to the officer going there and, interviewing people who said, yeah, they just seem a little off, or their girlfriend broke up with them and they've seemed really down for the last few weeks. Like that was sort of the dividing line.
Great. And then my second question, I'll go ahead and take it since I've already unmuted, is, I mean, I'm a New Yorker, and I'm really impressed by the large number of ERPOs coming out of New York. So I both wonder, is anyone looking at that data so that we could include it with the rest of the studies? Is there somebody working on that we could connect with, or was that hard because of our other, structures of reporting?
I don't actually know. I know I found the data from New York on a publicly accessible website, but I also remember reaching out to Grace Lee, who's like the director of forensic services for OMH in New York, and asking, like, are they tracking anything more granular than just the number of petitions? And I believe her answer was that that's not something that OMH is doing. So if there are, university-based researchers or things like that who are looking at it, hasn't come to my attention yet. I don't know, Mike, if you know anything more about New York.
I haven't heard of anyone specifically looking at that data in New York.
I think that's an invitation, Dr. Capasso.
I was going to say, Marc, you and I are going to have to take this on. Thank you for a really great talk. I appreciate it.
We have a really good question from Juan, wondering, are there models outside of the US that you are aware of that we can learn from?
Does anyone but the US have this problem of civilian access to firearms? Like I've given versions of firearms and mental illness talks at our British Forensic Psychiatry conference, at the Australian ones, and all of them just look at me like I have five heads. And they're like, you know what you could try is no one has guns. You know? Like they just find it so bizarre that we're trying to sort of slice so thinly about like who shouldn't have guns. They're like, the answer is everybody.
That is very true. And does anyone have any other questions? I mean, feel free to unmute, ask any other questions.
Missouri had a ERPO, but was it repealed or they just never had it? Maybe I'm mixing it up with something else. No, they never had it. Okay. Maybe it was a handgun licensing law or something. Maybe it was something different.
Yeah, you could, look it up on the Gifford website or the NCSL website.
So I give a class every year to the second year of psychiatry residents at Harvard UCLA on gun violence prevention. And so I talk about ERPOs. And you said that there was a study, 70% of physicians just really don't know these things exist. Do you know if this is now part of residency education for either psychiatry or just medical education in general, or for medical students?
I don't know about nationally. I know we don't do it at Yale that I know of in the psychiatry residency.
Yeah, it's not clear. As Reena was saying, the clinical paths through this are not really well formed at this point. And probably where we're left is that we should be trying to do the things that we know to begin with, having a discussion, trying to uncover what the problem is, trying to help with that. Maybe it's time to increase someone's medication. Maybe they need a higher level of care. Maybe they need to be hospitalized. Maybe it's time for a family meeting. Maybe brother-in-law Joe could take the guns for a while. All of these, the kinds of things that you negotiate with patients and families clinically before reaching out to law enforcement to help solve a problem. But exactly when you cross over that line from trying to manage this as a negotiated element of therapy and crossing into a law enforcement response is not exactly clear. When we did our key informant interviews, I neglected to mention that we did interview some clinicians, and there were two clinicians that we had talked to who had actually used the law, both of them with the patient's consent, and one of them worked reasonably well, and in the other one, the patient actually wanted to be rid of the firearms. The psychiatrist helped the patient by, at the patient's request, calling the police, and the police responded by sending a SWAT team to the patient's house. So it just scared the crap out of the patient, and it was not a particularly good outcome for that patient. So, these are the kinds of things that can happen. And unless you have a good relationship with your local police department, maybe in a smaller town, or maybe if you've been fortunate enough to have an affiliation with your police department, you may not have the kind of relationship that is going to guarantee a better outcome.
So, thank you. It's getting, close to 2 hours. So I think we'll probably wrap up. But this was extremely informative, extremely useful information. Thank you so much. Multiple people who had to drop off early messaged the chat or messaged me directly thanking us for doing this, saying it was really excellent. And it will be recorded on the website. So we'll send an email out and post about it once the recording is posted. But just a reminder that our website is psychgvp.org. And right on the website, there is, can't miss it. There's a button that says join us. So if anyone's not part of our organization and on our email list, you can click there and join us. And you'll get not that frequent email updates. You can also find us on Instagram and Facebook if you want to see social media posts as well.
I could offer a comment to Juan's last question.
Sure.
I don't think that that's been done yet, but we are looking into whether or not we might be able to do that. So the question was about interviews, qualitative interviews with the respondents and how they experienced it. We are looking into whether or not we can do that in Connecticut. We technically can probably do it. We can match, at least for people who have a connection to the Department of Mental Health and Addiction Services. And our idea is we can match those people up, get in touch with their clinicians, assuming that they're still in treatment, and through their clinicians, ask if they would be willing to participate. And of course, this would all have to go through IRB approval and all of that. But that's the methodology that we're starting to think about to doing for our next study.
I think we will wrap up, but many thanks to
Thank you.
Drs.
Thank you very
Kapoor and
much.
Norko. Yeah, thank you. And